All rise. We will away. Please be seated. We will as well.
Mr. Jeremy, just before you carry on, I gather that over the adjournment, you sent a response to a question in writing. And the whole point, it has become really confused, and I'm really sorry we began this exercise, is that we gave you and the defence advance notice of questions we were, Mr. Nichols, of advance notice of questions we might, underline, ask, and said it was up to you whether you chose to answer them during the course of your final submissions. The defence have already done that, and we pointed out that we weren't expecting answers in writing, although we accepted what you did. But now you're starting this, and the problem is the defence filed theirs, but you've put them in an email, and it's not on the record. So can we just say, if you want to answer the questions either side in the course of your final submissions, that's fine by us. But otherwise, we'll just ask them if we decide at the end of listening to everything you said that we still need to ask them. It may well be that we don't. But please don't answer it and certainly not by email. I think at some stage or other you have to put it on the record. Also, very helpfully, you filed a list of references that you didn't file. Sorry, you provided us with a list of references to what you were going to be citing in your final address. Very helpful, but it needs to somehow or other go on the record.
Thank you, Your Honor. Apologize for sending the email. That was my fault. Perhaps
Don't worry. No, I mean,
I had thought my friends had done it that way and had been accepted.
I know. But I said we did not expect answers in writing. But we accepted Mr. Louch's, we accept yours, but somehow you've got to file it.
Right. Otherwise, we can just do it orally as well.
Yeah, right.
Sorry, Your Honors, just before Mr. Jeremy continues, I made a mistake in this morning. I apologize to my friends and to Your Honors. This was at page 53, lines 25, continuing on to page 54. I misspoke and I said that we had closed our case in February 22. I was a year off and my math was wrong about the defense starting their case. So I apologize for that error. Of course, it was
23.
23.
Yeah. That's fine. Thanks, Mr. Nichols. Yes.
And before we close that, Madam President, how do you want us to proceed for the table of authorities?
That's a very good question. I suppose file them. What's the answer to that? I'm waiting for instructions, as you can see.
The registries are going to put it on the record.
So okay.
They will annex it to a registry.
All right. Yeah. I'm told the registry is... sorry, Mr. Louch, I'm told the registry will simply enter it onto the record. Thank you. Yes, well, all of that discussion doesn't count against your time. So off you go, Mr. Jeremy.
Thank you, Madam President, Your Honours. I move now to my third topic, jurisdiction. And I'll briefly outline the evidence that we say proves Abd-Al-Rahman, the accused, could reasonably have expected to face prosecution for the charged crimes. And our arguments on this issue are set out in paras 664 to 682 of our brief. Your Honours are aware of the Appeals Chamber decision on this issue. Excerpt of that is on our screen. And in essence, on the basis of their reasoning, you'll recall that the Appeals Chamber found that the accused was reasonably capable of taking steps to comprehend and comply with his obligations under international law, and he was capable of appreciating the attendant penal consequences. Now, your honours will consider this issue as part of your Rule 74 judgment, and based on the majority decision of the appeals chamber, the question for this trial chamber we submit is a simple one. Could the accused have reasonably expected to face prosecution under international law or domestic law for the charged crimes? Put another way, when the accused and his forces murdered and raped civilians in Khartoum and Bindisi, forcing them to flee their homes, which were pillaged and burned down, when he detained, tortured, and executed well over 100 men outside of Mukjar, and did the same thing outside of Delej, could he have reasonably have expected to face prosecution for this conduct? The evidence demonstrates that he could have this expectation, and to briefly demonstrate this, I want to go back through the timeline we looked at earlier of the accused's professional experience, and I want to plot onto that the various ways that Abd-Al-Rahman could have known that his conduct was criminal. Your Honours will recall that the government of Sudan confirmed that an interest in international humanitarian law within the Sudanese armed forces dates back to the establishment of that force in 1925, quote, when the first generations of human rights and the customs and traditions of war appeared in the Queen's orders to the British Army, end quote. And that's in paragraph 673 of our brief. Next, on the timeline, we see that Sudan signed the UN Charter in 1956. 1957, it accedes to the Geneva Conventions. In 1960, within the SAF, we learned from the government of Sudan that these Queen's orders were updated by what was called the list of individuals, and that that list stipulated the protection of rights and vulnerable groups, women, children, and civilians in the context of the armed conflicts. So by the time the accused joins the SAF, Your Honours, in Defence Day 1964, there is already an established framework regarding the protection of international humanitarian law in Sudan. As mentioned in paragraph 672 of our brief, in the 1970s, a witness testified that military college students studied military, civil, and criminal law, and that there were also, quote, some lectures about the international law, but in a very concise way, end quote. Another witness also confirmed not only that he knew that it was wrong to commit crimes against civilians, but that as a soldier, it was his duty to protect civilians and not murder them, as that would be against the principles of being in the military. And Your Honours will recall that this evidence came from someone with a rank far more junior than that achieved by the accused, but that witness, and we see the quote on the screen before us, was nevertheless aware that if he killed a citizen, he would be held accountable not only by God, but by a court. So for these persons who were part of the SAF at a similar time to the accused, it was accessible, it was foreseeable that crimes could not be committed against civilians, and that provisions of IHL needed to be observed. Moving forward, in 1986, Sudan signs a number of human rights treaties which establish the protection of fundamental rights. We heard from a witness that in 1988 that there was an approach, he heard about an approach to IHL within the SAF, and that he was aware of training manuals that were issued in the 90s. The criminal code applicable at the time was enacted in 1991, and much of the charged crimes were criminalized under that particular act, which a witness confirmed was applicable to persons subject to military justice. And we outline that evidence in paragraph 667 of our brief. And it is also notable, Your Honours, that while the accused was in the SAF, based on his rank, he would have been promoted 5 times. And Your Honours will recall the evidence from a witness that stated that promotion within the armed forces is linked to time and the gaining of further qualifications. And I refer, Your Honours, to transcript page 130, page 11, and the Armed Forces Act of 1986, DAR OTP 00006136, page 16. Your Honours heard evidence that in 1996 there was training on general guidelines of IHL, which was provided to SAF forces going on operations. In 1998, you heard that there was a new Sudanese constitution which contained a Bill of Rights. And you'll recall the evidence that we heard about the training manual from the year 2000 that was used by the SAF to train troops of various ranks, including non-commissioned officers. And you'll recall that notably in this manual, it stated that the Geneva and the Hague Conventions include much of the content of Islamic teachings from 14th centuries earlier, in particular the principles of distinction and proportionality. And Your Honours will recall that that evidence is supported by evidence from D16 and D8. In 2002, Sudan signed an agreement with the SPLM in which the parties undertook to comply with their obligations under international law, including Common Article 3 of the Geneva Conventions. Moving forward to the 2003 and 4 conflict, Your Honours will recall the evidence we outline in paragraph 677 of our brief, which was significant. We heard that the Military Justice Department of the Sudanese Armed Forces had offices in units in Darfur, and that legal advisors would provide briefings on IHL before operations in Darfur. And Your Honours will also recall that in the course of attacks, in the course of charged attacks, the accused himself was confronted by individuals concerned by the immorality and the illegality of his actions, and that he dismissed those objections. We have one quote on the screen before us from witness P878, transcript page 78, page 41, who recalled an Umda said to the accused during the Kadum and Bendizi operation, quote, "Ali, what you are doing here does not please God and doesn't please his prophet. And you said that you're not going to hit any person, nor kill any person, nor burn any house. You said you will only do that to anybody who's carrying a weapon and resisted you. But what you're doing now is not right." And Your Honours, here I want to focus on something that the defence say in paragraph 796 of their brief, where they quote, "warn against any legitimate cultural bias that the Western legal education of all protagonists of the trial may induce," end quote. They also state that, quote, "one shall not assume that the most basic principles of IHL were known and understood by any Darfur layperson in 2003 and 4. Now, Your Honours, I would respectfully suggest that this is a deeply flawed and rather insulting characterization of Darfurians. The evidence clearly demonstrates that even for witnesses who did not have Abd-Al-Rahman's military experience, who did not have his leadership role, his proximity to senior members of government and military, it was foreseeable and accessible that the charged crimes were criminal. And a further demonstration of this clear criminality of the accused's conduct is demonstrated by the various justice mechanisms, Your Honour, however flawed they may have been, that were set up by the government of Sudan after the charged crimes, many with the specific mandate to investigate human rights and IHL violations. And Your Honours are aware of one such investigative body which interviewed Abd-Al-Rahman in 2006. And during that interview, he demonstrated an unambiguous understanding of the need to protect civilians in conflict. And we see a quote from that interview on the slide before us, where again he states, "We were fighting against people who were outlaws and not ordinary citizens." Earlier he says we were acting in accordance with the instructions of the state for the purpose of protecting civilians. Now, Your Honours, we would submit that in this interview, the accused is obviously seeking to protect himself, but nevertheless, he clearly demonstrates that he, far from being a perfect layman, as the defence suggests, he could reasonably have expected to face prosecution for his conduct under both international law and domestic law. Your Honours, this brings me to the fourth and final topic of my submissions, the Khartoum and Bendisi attack. The evidence led in this trial proves that on around the 15th and the 16th of August 2003, Janjaweed and GOS forces, led by the accused, attacked several predominantly Fur villages, culminating in an attack on Khartoum and Bendisi. As demonstrated by the evidence listed at paragraph 267 of our brief, there was no rebel presence in the villages attacked, although there was resistance by a few armed individuals. In this regard, I want to highlight that in its brief, paragraph 358, the defence refer to evidence from witness P87 to suggest that there were rebels in Khartoum, and in doing so they refer to paragraph 157 of that witness's statement. As Your Honours will see when you go to that paragraph, the witness is not referring to rebels in Khartoum, but rather rebels in Khartoum, which is 300 kilometres away. Now, Your Honours, in the course of this continuous attack, in addition to the attacks on Khartoum and Bendisi, the civilian population in Niali, in Tiru, Seder, Murli, and Jangal were also attacked. Turning to the crimes committed specifically in Khartoum and Bendisi, and commenting briefly on the general reliability of evidence in relation to this incident. As we set out in paragraph 266 of our brief, the evidence of this attack was provided by 27 witnesses, 4 of whom were very well placed insiders from very relevant backgrounds, whose evidence overlapped considerably, particularly in relation to the modus operandi of the attack and the accused command role. In relation to this command role, we set this out in paragraphs 349 and 393 of the brief, but the evidence shows that the accused was present and leading the operation that left from Mukjar and culminated in the attacks on Khartoum and Bendisi. We submit, Your Honours, that the defence efforts to contest his leadership role have no proper basis. I'll briefly go through some of that evidence now. The defence somewhat bizarrely suggests that Abd-Al-Rahman was not even present in Bendisi during the operation. In making that assertion, they rely on the evidence of P905. And you recall that P905's evidence related to the Sindhu operation late December in the early months of 2004. And he stated that in the course of that operation, one of the accused deputies, Aldev Sema, attacked Bindisi before joining the accused on the Sindhu operation. As Your Honours will see from that evidence, transcript page 88, T88, page 51 to 53, he's clearly referring to a different attack on Bindisi to the one that we charge in August 2003. The accused's authority, his command, his control is confirmed by multiple witnesses. And contrary to the defence submissions, for example, in paragraph 356, it wasn't diluted by the presence of members of other forces, such as the CRF or the PDF. As regards the CRF, the evidence does demonstrate that CRF were present. However, as witness evidence makes clear, for example, in paragraph 353 of our brief, the CRF commander could not oppose the accused and told his forces not to intervene and comply with the accused's request for ammunition. A witness also testified that he was, quote, not in a position to address the accused because he had an overwhelming force, end quote. That's paragraph 353. PDF coordinators were also present, but the evidence demonstrates that they too were subordinate to Abd-Al-Rahman. One of them stated that he couldn't question the accused's authority during the attack, otherwise he would become, quote, roadkill. That's paragraph 353 of our brief. And more generally, the evidence demonstrates that the PDF coordinators were civilians without a command role. That's paragraph 76 of our final brief. Now, through his position and authority, his words and conduct, the accused ordered and induced the Janjaweed militia forces under his command to commit the charged crimes, including his Agids, Bonjus and Sama, who in turn passed those orders to their men. And this evidence, Your Honours, is set out in paragraphs 355 to 382 of our brief, and I'll provide a brief overview of it now. The first villages attacked in the operation were Niurli and Tiru. Your Honours will recall that P921 saw burning, killing and beating in Tiru, and the militia Janjaweed throw people, including children, into burning houses. And the evidence shows that persons in Tiru, in Niurli, were murdered, raped and chased, and property was looted and burned. The accused gave orders in Niurli, ordering his men to move towards the village, and ordering the PDF coordinator to move behind him. He also ordered the militia Janjaweed present to attack by shouting, Allahu Akbar, wipe out and sweep away, Amsa Aksa. And a witness also heard the accused saying to militia Janjaweed, kill everybody, wipe out, and cut the straw and eat it raw, in the midst of the ongoing burning down and killing. And as we set out, Your Honours, in paragraphs 360 to 362 of our brief, these expressions, when considered in their proper context, were orders to the men under Abd-Al-Rahman's command to attack the civilian population in these villages. Contrary to the defence submissions, they were not motivational chants intended to lift the morale of the troops. Moving forward to Kadum, upon reaching Kadum after the attack continued in Tiru, the accused issued orders to Hazabala about where to go within Kadum, and insider witnesses are consistent in describing the same modus operandi, the same pattern of attack, which was employed in Kadum as was employed in the preceding villages. And that pattern included, as we set out in paragraph 276, attackers chasing people, women, like a dog chasing its prey, as if they were not humans. people were murdered and raped, items were pillaged and homes destroyed. In Kadum, a witness, as we set out in paragraph 275, heard the accused give orders to Sameh and Bonjus, his Agid, sub-Agid commanders, to continue working and saying, anyone you see, kill him. And a witness also heard the accused use this same motto, cut the straw and eat it raw, while the attackers were busy shooting and burning the village. The accused convoy then moved to Bindisi, and upon arriving in North Bindisi, militia Janjaweed continued their attack. They continued to loot, they continued to burn, to murder, and to rape, as we set out in our final brief. Following that attack on the 15th, there was a pause, as your honours will recall, an overnight pause in the attack. And during that pause, the accused took the opportunity to offer praise to his men. He aggressively countered objections to his conduct, and he ordered the attack to continue on the next day. The evidence makes clear that in that evening, while they were camped, the accused gathered 15 to 20 of his Janja militia sub-leaders or Agids, and he told them, quote, "You've taught the enemy a lesson that the enemy will never forget. The foe will never forget this lesson, and God willing, tomorrow we will go to Garcilla, where a big celebration will be held for us by Jafar Abd-Al-Rahman." And then the next morning, your honours will remember that the evidence is that the accused then changed his orders. He summoned his forces again. He said he had new instructions, and those instructions were to continue the attack on Bindisi. Clear orders, your honours, for the continuation of this attack. And indeed, that is exactly what happened. As we set out in our brief, the attack continued in Bindisi on the 16th, and notably, witnesses, including P12, saw him in South Bindisi, giving orders to militia Janjaweed as they looted, killed, and burned, and the Agids in turn relayed his orders to their men. Moving to my final point on this attack, your honours, the rape charges. The evidence demonstrates that rapes, outrages upon personal dignity, and other inhumane acts occurred on around 15th and 16th of August 2003 during this attack. Evidence is provided by direct victims, P11, 1073, 1074, as well as direct eyewitnesses. And we set those out in our brief, paragraph 323. As regards your honours, question 20, which focuses on the accused mens rea in relation to counts 8 and 9, the core of that evidence that proves that Abd-Al-Rahman is responsible for the crime of rape is set out in the final brief, paragraphs 379 to 391. And we set out bullet points of that evidence in brief on the slide. I won't go through it all now, but I will emphasize the rape and mistreatment that occurred in villages attacked immediately prior to and after Bindisi. And then the last indicia, which is Abd-Al-Rahman's orders to commit violent crimes. And it's on this final category that I just want to briefly focus, your honours. And in doing so, I want to highlight case law from the Entaganda trial judgment that we reference in footnote 1328 of our final brief. Now, as I've made clear, the evidence clearly demonstrates that during the course of the operation to attack Kadum and Bindisi, the accused issued orders to his men to carry out attacks in the course of which rapes occurred. These orders included saying, "Amsa Aksa," cut the straw and eat it raw, and multiple witnesses testified that these were orders to commit violent crimes against civilians. For example, 91 stated that in Khartoum, following Abd-Al-Rahman's order, following his use of this expression, cut the straw and eat it raw, the Janjaweed started looting, killing, burning and raping. That's paragraph 380. Now, the Entaganda trial judgment considered the significance of an expression commonly used by commanders to convey orders to soldiers. For example, in paragraph 415 of their judgment, they found that this was an expression that was commonly used in commanders' orders to soldiers, and that it was understood by the soldiers to mean, quote, attacking all the Lendu, including civilians, and to loot their property. Now, as regards acts of sexual violence in that case, the Entaganda chamber found that the way that the operations unfolded showed that the acts of sexual violence, like the killings, like the other physical violence, were a tool used by the commanders and the soldiers to achieve their objective to destroy the Lendu communities in the localities under assault. Similarly, Your Honours, in this case, acts of rape, like other violent crimes, were used as a tool to achieve the objective of attacking, destroying these communities in the Bindisi locality. For example, acts of rape and the other charges charged under counts 6 to 9 also overlapped, were committed in the course of other violent crimes such as murder and looting. And in this way, rape was an integral part of what a witness described as, quote, the operation to kill, rape, displace, and burn the population of those villages. That's T78, page 23. The Entaganda chamber also found that during the rapes, the perpetrators would compare their victims to non-human elements. Similarly, in Bindisi, as set out in paragraph 380 of our brief, while committing rapes, the militia Janjaweed would use derogatory language, calling their fur victims Nuba and Tora Bora. While they committed rape, they would thank Omar al-Bashir for giving them the opportunity to do that. They would state that they were the men of Ali Kushaib, and they would state that they had permission from the government of Sudan to wipe the victims out, kill them, and chase them away as if they were of no benefit. Again, Your Honours, we see the same pattern in this case as we set out in our final brief, in particular in paragraphs 333 to 335. And owing to the devastating impact of the way that these rapes were carried out and the humiliating ways that the rapes were perpetrated, the rape committed in Bindisi was used as a way to destroy not just the women as the community, but the community as a whole. And the Entaganda chamber concluded that in giving orders for troops to attack, using this particular expression from that case, Entaganda necessarily meant to attack everyone and everything, targeting civilians and their properties and committing rapes and murders. And we respectfully submit, Your Honours, that similarly, in this case, it is clear that sexual violence, like other violent acts, were integral to the attack led by the accused on Khartoum and Bindisi. Sexual violence, like other violent acts, were therefore integral to the orders he issued during the attack, orders conveyed using the expression, cut the straw and eat it raw, using the expression, wipe out and sweep away. And in issuing these orders, he meant to attack everyone and everything, an attack that he knew would include violent acts, and of course an integral part of that, of those violent acts, would be sexual violence. Thank you, Your Honours. That concludes my submissions.
Yes, thank you very much, Mr. Jeremy. Yes.
Good afternoon, Your Honors. My name is Laura Morris, and I will be addressing the arguments raised by the defense in relation to Mukhtar and persecution. Your Honors, the accused bears criminal responsibility for the mistreatment of detainees at Mukhtar police station in early March 2004. The accused bears criminal responsibility for the murder of 177 detainees transported to locations outside of Mukhtar and the attempted murder of 2 men who miraculously survived. Despite the fact that it was a staffed and functioning police station, the evidence shows that the accused had unimpeded access to hundreds of detainees at Mukhtar police station. The accused oversaw the mistreatment by militia, Janjaweed, and government forces. The accused was also an active participant, striking several detainees with his signature weapon, an axe. The accused had the authority to enter the cells and remove detainees. The accused oversaw the detainees being loaded onto vehicles in the presence of the Commissioner of Mukhtar, Abd-Al-Rahman, and the head of the police and Central Reserve Forces, the official in charge of Mukhtar police station, Mustafa Al-Tayyab. The accused's vehicle was lead in the convoy as it departed Mukhtar police station. Your Honors, the accused had control over the fate of these detainees. In a matter of hours, an estimated 177 males were driven to 3 sites outside of Mukhtar and summarily executed. Their bodies were left to decompose in piles for villagers to discover until around a month later, when GOS forces hastily reburied some, leaving mounds of soil and blood-stained clothing strewn around the site. The accused's pattern of mistreatment and execution of detainees would be repeated again in Delege about a week later, as my colleague will discuss. The defense strategy is to insist that the accused had no authority. They minimize his role, inflate the authority of others, and even try to pin criminal responsibility onto others. They argue that the local government and military infrastructure left, quote, no room for the accused to hold any position of authority, despite the evidence clearly showing otherwise. The evidence the prosecution relies on comes from those physically present at the police station during the charged events. It comes from witnesses who were in those cells. It comes from witnesses the accused personally struck with his axe, who still have gashes on their limbs 20 years later to prove it. It also comes from witnesses who were present in their official capacity as military or police officers and who identified the accused as the one who possessed the authority. Your Honors, the evidence from the 20 witnesses that the prosecution rely on for Mukhtar is credible, reliable, and corroborated. And when viewed as a whole, it demonstrates beyond a reasonable doubt that the accused is criminally responsible for the charged crimes. My submissions will first address the issue of the accused's authority, then the arrest of males, the mistreatment and torture of detainees at the police station, including by the accused, the loading of detainees onto vehicles for execution, and the execution of detainees in 3 locations following the accused's orders. In paragraphs 450, 484, and 496 of the defense final brief, in an attempt to minimize the accused's role, The defense spent pages setting out the purported local military, administrative, and political structures in Mukjar at the time, and conclude that there was no room for the accused to have authority in Mukjar. Despite this effort, the evidence on record shows that by early March 2004, the accused was cooperating with senior government officials, including at the locality level, cooperated with and exerted authority and influence over certain members of government forces at the locality level, and issued orders to members of GOS forces, particularly of lower rank. And this is the prosecution final brief, paragraph 127, Your Honors. While cross-examining witness P984, the defense suggested to him that because the accused was not from Mukjar, he had no authority there. P984 flatly rejected this, making it clear that when it came to the accused, local government and military structures were rendered meaningless. Quote, "This person, he was getting his orders from the center, from Khartoum directly. All the leaders who were in the area of Wadi Saleh were under his command. No one was higher than him in the hierarchy." And that's at transcript 66, page 9 to 10. The accused used his direct line in material support from State Minister for the Ministry of the Interior, Ahmad Haroun, as a means of exerting his authority over local officials, including Commissioner Torshine and the head of police, Al-Tayyab, when they dared challenge him. During a 2004 meeting between the accused, Torshine, and Al-Tayyab, the accused was upset he had lost so many men in combat and wanted revenge by killing the internally displaced persons in Mukjar. Torshine and Al-Tayyab tried to reason with the accused. Furious, he replied, and I quote, "I can communicate directly with the minister. Who are you to tell me this? I would only waste one bullet to get rid of you." This is 0218-0021 at paragraph 93. Prior to removing the detainees from their cells on the day of the execution, the accused told Commissioner Torshine, quote, "My instructions come from the minister. I don't take my instructions from a wali or a mutamid or anyone. I take my instructions from the minister himself." And that's the prosecution final brief, paragraph 481. The defense also tried to shift responsibility for the charged crimes onto others, such as Lieutenant Colonel Al-Jili, head of the police, PPF in Garcilla. At paragraphs 524, 526, and 541 of the defense brief, they unsuccessfully suggest that he was in a position of authority, not the accused. The defense claim Al-Jili halted the convoy headed for execution, citing to P931, however misstate 931's testimony. This witness actually testified that they left the police station, drove a short distance, and the vehicle in front of his stopped, so Al-Jili ordered the vehicle he was in to stop. The defense go on to suggest that Al-Jili also had the authority to order the unloading of detainees, defense paragraph 526 and 541, but they provide no evidence to support this. Notably, when the defense suggested on cross that Al-Jili had authority over the executions, this line of questioning went nowhere. Attempts in the brief by the defense to suggest that Al-Jili had authority should be afforded no weight. This is at transcript 63, page 17. Regarding the accused's role in arrests, at defense paragraphs 468, 486, 543, and 544. Contrary to the defense argument that the accused did not play a role in arrests, this is another effort by the defense to not view the evidence in its entirety. As set out in paragraphs 492 of the prosecution brief, prior to departing Mukjar for the Sindhu operation, the accused instructed Al-Tayyab to arrest anyone from the direction of Sindhu. The accused told Al-Tayyab that, quote, "They must be registered by you here, and they must be kept until we return." The accused threatened Al-Tayyab that he would be held accountable should his instructions not be followed. That's 492 of the prosecution brief. And follow he did, Your Honors. Upon returning from the Sindhu operation in early March 2004, the accused went to Mukjar police station, where the cells were packed with males arrested at checkpoints coming from villages northeast of Mukjar with detainees, just as he had instructed. Regarding the targeting of 4 leaders in the defense brief, paragraphs 471, contrary to the suggestion by the defense that the targeting of 4 community leaders was an explicit policy of the government of Sudan, evidence from multiple witnesses, including insiders, shows that community leaders arriving from outside Mukjar were targeted and arrested because they were perceived as being affiliated with or supporting the rebels. This is paragraph 401 of the prosecution final brief. In his 2006 GOS interview, the accused himself stated that 4 Umdas were responsible for leading the rebellion. That's 0219-7007 at 7015. In support of the defense argument that community leaders were not targeted, the defense cited the example of the Sharteh of Mukjar, Omar Ahmed Zaruk, and his sons. This is defense brief 471. The defense misleadingly used the example of the Sharteh's 2 sons, who expressed sympathy for the rebellion and were arrested and detained but not executed. Your Honors, the defense are describing an incident that took place in August 2003, not March 2004. They mischaracterize the evidence to support their argument in the brief. Evidence from this case actually shows that in early March 2004, one of the Sharteh's sons, Dr. Muhammad Umar Ahmed Zaruk, was arrested. He was detained and he was executed by the accused, militia, and Janjaweed forces. This is at paragraph 420 and 463 of the prosecution brief. His name appears in the list of victims, Annex 17, number 134. The defense also argue that the arrest of hundreds of males, including at checkpoints, cannot represent all or the majority of 4 males in the area. There is no numerical requirement or threshold. Furthermore, the fact that certain males were not arrested does not detract from the targeting of the perceived group, contrary to defense paragraph 543. Regarding torture and mistreatment arguments in the defense brief at paragraph 550, upon entering the cells at Mukjar police station, the accused had full custody and control over the detainees. This is at paragraphs 411 and 432 of the prosecution brief. The accused's custody and control is demonstrated by the evidence. The accused had unimpeded access to detainees at Mukjar police station over the course of 2 days. The accused and his forces mistreated detainees, including important community leaders, in the presence of the head of the police station, Al-Tayyab, and CRF officer and guard, John Coy, both who the defense say were in charge, responsible, and had authority over Mukjar police station. This is citing to defense brief 496, prosecution brief 433 to 438, and 442 outline the responses. There is no evidence in this case that either Torsheim or Al-Tayyab took any steps to exert their supposed authority to stop or forbid the accused at any point during the commission of those crimes. These incidents took place in a fully staffed police station where the police and CRF were based, Yet the accused had authority to do as he pleased, and no one dared to stop him. Regarding the specific the purpose element for torture as a war crime, the evidence shows that the pain or suffering was inflicted to punish, intimidate, and to discriminate. A few examples. Upon entering the cell on the first day, the accused addressed Umda Yahya and, quote, said, "I detained you in the past and I released you, but this time I'm going to kill you." The accused struck Umda Yahya and then proceeded to beat the other 4 Umdas and several detainees with his axe. This is prosecution brief 419 to 420. In the accused's presence, militia Janjaweed used knives to shave the heads of 2 detainees and cut the ears off of 3 others. Hamdi pointed his gun in the faces of detainees, demanding to know where someone named Harun and someone named Isa were, and said, "Toroboro, we will finish you." One soldier threatened detainees, saying, "We will fuck you, we will rape you." Another stomped on detainees with his boot. This is prosecution brief 422. Your Honors, whether there was some other purpose behind this violence is immaterial. The jurisprudence of the ICC and ad hoc tribunals is unequivocal. Citing to Ongwen trial judgment, paragraphs 2706, I quote, "The specific purpose," referring to the purpose element, "must be part of the motivation behind the conduct, but it need not be the predominant or sole purpose." The evidence of mistreatment of detainees by the accused is credible, reliable, and corroborated, contrary to defense arguments at paragraphs 501 to 506. The defense concede that the mistreatment of detainees at Mukjar police station is corroborated by several witnesses. However, cynically, they suggest the reason for this is because the detainees who testified suffer from, quote, "a phenomena of collective memory." This is at defense brief, paragraph 501. Through quoting selective passages of testimony and mischaracterizing the evidence, the defense proceed to allege witness contamination so as to conclude that these witnesses should not be found credible. If, as the defense suggests, the witnesses had, quote, shared stories for several years, why are they not more identical, more uniform? There is no basis for this allegation. The evidence witnesses provided are from the perspective of detainees in a packed cell, fearing for their lives, witnessing various incidents of mistreatment by the accused and militia, Janjaweed, and GOS forces at the same time, in terrifying circumstances. That a neat and clean account does not emerge is not expected, nor would it be credible. The defense suggests collusion or contamination between some of these detainees, including P892 and P877. However, checking the footnote, one finds the allegation is testimony from P892 saying that P877 at one point told him he was a detainee and nothing more. Similarly, with no evidence in support, the defense speculate that because P877 and P932 met after the events, it, quote, thus cannot be ruled out that they discussed the alleged events. Notwithstanding the fact that some of these witnesses are direct victims of being struck by the accused's axe or witnessed the accused strike members of their own family, there is no evidentiary basis for the defense to suggest anything other than these witnesses were telling the truth. At paragraphs 514 to 516 of the defense brief, the defense further attempt to chip away at the strength of prosecution evidence that the accused mistreated detainees by suggesting that there are 3 versions of events. This, Your Honors, merits correcting. Multiple witnesses testify as to the following. Both P919 and 129 witnessed the accused enter the cell and strike Umda Yahya with his axe. This is at paragraph 419 of the prosecution brief. Witnesses 919, 129, and 990 witnessed the accused strike Umda Isa Harun Noor with his axe. P919 testified that during this same incident, militia and Janjaweed used knives to shave the heads of, of 2 detainees and cut the ears of 3 others. This is the same day, same events, not a different version, as the defense would like you to believe. I refer your honors to paragraphs 411 and 423 of the prosecution brief. The defense assertion that according to one witness, P903, the accused did not come inside the cell is evidence he gave about the second day of mistreatment, not the first. Given the importance of P129's evidence, the defense take advantage of a moment of confusion that P129 experienced on cross-examination as to the timing of a public speech he heard to suggest that all of his previous evidence relates to an entirely different episode of detention. To correct the record, Your Honors, as a 68-3 witness, P129's evidence as to the sequence of events and mistreatment from the accused is clearly set out in his first and third statement, as well as his clarification log. His evidence of mistreatment, loading onto vehicles, and execution is corroborated by both crime base, witnesses, and insiders. For the defense to argue that P129's first statement, he did not specify if he saw the accused during his first or second detention, is illogical. P129 describes his second detention in great detail, and the accused appears nowhere in that account. Your Honor, there is nothing in his testimony or statements to credibly suggest that P129's evidence about the charged events relates to his second detention. It is also important that P129's trauma, reliving events on the stand, be factored into assessing this momentary confusion he experienced. The defense should not be able to capitalize on this. Turning to the evidence relating to the loading of detainees onto vehicles for execution. The authority of the accused during the loading of detainees in the presence of Commissioner Torshine and Head of Police Al-Tayeb was touched upon at the beginning of my submissions. However, I wish to emphasize a few additional points. On the day of the executions, the accused and co-perpetrators Idris Abd-Al-Rahman went inside the cells at Mukjar police station with a purported rebel they had captured from Sindhu. Instead of targeting those whom the rebel pointed out as possible suspected rebels, the accused simply declared the detainees were, quote, all Tora Bora. This is prosecution brief 233 and 432. Commissioner Torshine and the head of police, Al-Tayeb, were informed by the accused that he was taking the detainees from Mukjar police station to Zelenji prison. The accused informed the head of police, Al-Tayeb, that all detainees had to be handed over to him. The accused was not stopped or prevented from doing so, despite having struck at least 14 detainees with his axe, and despite these detainees being gravely injured, and, importantly, despite having no official, formal role responsibility for these detainees, as the defense repeatedly insist in their final brief at paragraphs 450, 478, 79, 484, 496, 526, 527, 541, 553, 558, and 559. The convoy departed Mukjar police station with the detainees loaded onto several vehicles. The accused was in the lead vehicle. Hamdi, Hasabala, Bakat, Idris, Al-Jili, and Sami followed behind. Paragraph 442 to 444 of the prosecution final brief. Your Honor, the evidence shows that Al-Tayeb showed up at the first execution site after the killing had started in an attempt to negotiate with the accused and perhaps try and stop the killing. However, the accused simply told the police chief, well, This is our operation. This is our work. Notwithstanding the effort from the head of police, the convoy continued on. Regarding Defense Annexes 3 and 4, in an attempt to undermine the corroborative evidence about the loading of over 100 detainees onto 6 or more vehicles destined for execution, the defense have created 2 charts. Annex 3 purports to summarize the evidence relating to the loading of detainees. It attempts to create the impression that there is a large discrepancy regarding the numbers of detainees loaded onto vehicles. However, the evidence relied on mischaracterizes the evidence and selectively quotes from testimony. For example, P12 clarified he did not count 52 detainees loaded onto vehicles. That number merely refers to some of the bodies that were later found outside of Mukjar. P29 testified that he witnessed the accused hitting detainees with his axe outside and load around 46 men onto 2 or 3 vehicles. However, his testimony suggests that additional detainees may have been loaded onto other vehicles in the next sentence of the transcript, when he speaks about 300 people being killed. Contrary to what is listed in Annex 3, P129 denied hearing an order to take out 52 detainees. He corrected this number and said it was more accurately around 100. This is at paragraph 72 of P129's first statement, and third statement, paragraph 52. This estimate is consistent with the other 2 well-placed witnesses who were present, namely P905 and P919. P905 estimated about 100 detainees loaded onto an estimated 6 vehicles. P919 provides a similar estimate of 100 detainees loaded onto 5 vehicles. Regarding the other 2 witnesses present, P984 and P931, P984 said he did not witness the loading and does not know the exact number, and P931 provided no estimates. Your Honors, the estimates may vary, but the high number of 100 or more detainees loaded onto several vehicles is the consistent estimate. Regarding the first execution site, the evidence relating to the accused ordering the killings of detainees at the first execution site is corroborated by the 5 witnesses who were present: P919, 129, 905, 984, and 931. The defense argue, despite the fact that 5 witnesses were present, that the accused did not have and could not have ordered the executions. They try to pin it again on al-Jili in a sentence that provides no supporting evidence. This is the final brief of the defense, paragraph 541. I wish to specifically address briefly the suggestion that P919 could not recognize the voice of the accused, defense brief 539. One does not need to see someone to recognize their voice. By this point, 919 had heard the accused speak over the course of 2 days. There is no reason he could not recognize his voice, the accused's voice, the next day. When the defense attempted to challenge him on cross about this, he was unwavering. Quote, "I recognized him because he visited us in prison twice, once in the morning and one in the evening, and I heard him again at the execution site. I recognized it. It was the same voice." That's transcript T61, page 32. Regarding Annex 4, the defense compiled another chart about the supposed discrepancy over the name of the first execution site and the number of victims killed at this location in an effort to make the evidence appear less corroborated than it is. The fact that 3 of the 4 witnesses present were not from Mukjar and may not have known the specific name of the corps is something the defense do not acknowledge. The defense are also silent on the fact that witnesses reference the location of the first execution site as being near a sycamore tree and a whore. 3 witnesses, P877, 129, and 984 refer to the location of the core using the sycamore tree as a reference point. Two other witnesses, P984 and 877, refer to the large sycamore tree beside the core as a marker to describe the location. An additional 5 witnesses consistently locate the site near a core close to where the Unimid base would later be located. I refer, Your Honors, to footnote 1515 of the prosecution final brief. The defense attempt to assert that the discrepancy about the numbers of victims casts doubt on the reliability and credibility of P905, 931, 984, and 919. P905 estimates about 100 detainees were executed. P931 did not see. P984 did not witness the beginning of the execution, so could not provide an estimate. One witness was not able to see, as explained at paragraph 449 of the prosecution final brief. Regarding the third site, the defense call into question the exact location, comparing 129's estimation with evidence from other witnesses who were not present. That others subsequently heard about the location and provide less accurate estimates is immaterial and does not impact P129's credibility. Your Honors, the evidence establishes beyond a reasonable doubt that the accused is responsible for the charged crimes in Mukjar, early March 2004. Now, with your indulgence, I will, in my remaining time, speak briefly about the persecution charges. The defense primarily take issue with the framing of gender persecution charges under counts 21 and 31, persecution on political, ethnic, and gender grounds in Mukjar and Delej. My submissions in my remaining time will focus on those. As Your Honors have heard, over the course of a few hours, the accused and his forces loaded an estimated 177 males onto vehicles at Mukjar police station and executed them. Around a week later, the accused and those same forces would travel to Delej. At Delej police station, they would load another 130 males onto vehicles and execute them in a similar fashion. Tragically, for these over 300 males, and likely unbeknownst to them, their fate was sealed because in the eyes of the perpetrators, they fulfilled the criteria which put them in the target group. For Mukjar and Delej, the factors or proxies for the perpetrators identifying their target group were 4 males from outside Mukjar, primarily of fighting age. Persons fitting those factors or proxies were then assumed or perceived to be rebels or rebel sympathizers. The defense agree on the factual foundation of the charges for gender persecution. For Mukjar, in their final brief, throughout, they say rebels or men, 4 males in age of combating, perceived as rebels, majority 4 men. Next slide. In Delej, they happen to all be males, paragraph 646 of the defense brief. Your Honors, in Mukjar and Delej, the male victims were targeted for arrest based on these proxies, without proper scrutiny. There is no evidence the perpetrators only targeted individuals on the basis that they were rebels, but rather on their belonging to a group. The defense submit that the perpetrators did not target the victims, quote, by reason of their group identity, but rather because they belonged to or supported the rebellion and thus constituted the enemy fighter. Defense brief 542 to 544. There is no evidentiary basis to conclude that the victims actually belonged to or supported the rebels. The prosecution do not say all men in Mukjar and Delej were targeted, contrary to paragraph 673 of the defense brief, just those suspected of being rebels, i.e. primarily 4 males coming from outside of Mukjar and Delej. This is prosecution brief 403. The evidence shows that the majority of 4 males detained at the 2 police stations were not questioned as to their actual involvement or support for the rebels. They were simply presumed, based on the fact that they were 4 and male arriving from certain areas outside Mukjar and Delej. The defense attempt to depict the arrest at checkpoints as premised on a list, defense brief 486 and 649. Your Honors, no prosecution witness testified that the basis for their arrest was because their name appeared on a list. To the contrary, the majority of witnesses who testified had no idea why they were arrested or were not given a reason. This is prosecution brief 402 to 410. The defense cite to witness 922 evidence that lists at checkpoints contained names of prominent figures like umdas, sheikhs, rebel leaders, and influential people suspected of having led or supported the rebels. However, one paragraph later, P922 goes on to say that those with no marks, or whose names were not on the lists, but looked young and strong, were suspected of rebel activity and would be arrested. This is 0224, 0023, paragraph 77. This corresponds with the evidence which has emerged at this trial. Prosecution witnesses and detainees denied having anything to do with the rebellion. They did not support the rebellion. They were not questioned prior to their arrest about their alleged association with the rebellion, even when having their belongings searched or being checked for marks on their shoulder at checkpoints. They were not found carrying weapons. They knew nothing of the rebel movement. They were fleeing forces who had attacked their villages. They were seeking safety. As the defense point out, in Mukjar and Delej, a select number of detainees were released from detention when and where their identity could be vouched for, or when a sheikh could promise good behavior. The act of releasing detainees shows that unless proven otherwise, all of those arrested were presumed or perceived to be rebels. Next slide. At paragraph 676, the defense argue that, quote, the OTP decision to intersect charges with additional grounds and acts appears to be aimed at introducing new standards for gender persecution. Your Honors, intersectionality is a tool to analyze the factual reality in a given context, to fully capture and describe forms of discrimination which would otherwise be lost or factually not captured. The notion of intersectionality of different discriminatory grounds simply recognizes the multiplicity of grounds as a matter of evidence, not as a matter of law. These multiple intersecting discriminatory grounds on political, ethnic, and gender best describe and fully capture the reality of the ways in which the accused and others carried out their discriminatory targeting. Contrary to paragraphs 667 and 670 of the defense brief, the definition of gender as perceived social construct of men as rebels is not a new ground for discrimination. The prosecution did not introduce a new ground, nor is it putting forward a novel legal theory or standard for gender persecution. Perceived social construct is simply a factual description as to how, in this case, the discriminatory grounds played out and were defined. The definition of gender in Article 7.3 refers to the two sexes, male and female, within the context of society. Perceived social construct is not a ground. It is simply a way of expressing the definition of gender within the Rome Statute. It is a way of defining, quote, within the context of society. In addition to the sex-specific pattern of targeting in Mukjar and Delej, the defense have acknowledged that in a patriarchal context of Sudanese society, male equal rebel and rebel equal male. This establishes that the perception of fighting-age 4 males as rebels is gender-based, and their targeting is discriminatory on the grounds of gender, as defined in Article 7.3. Your Honors, at paragraph 543 of the defense brief, the prosecution does not have to prove that the perpetrators intended to destroy, in whole or in part, the group. The defense appeared to conflate the two standards. This is paragraphs 543 and 647 of the defense brief. In relation to the mens rea, my final point, the accused was sufficiently aware of the consequences of his actions and the relevant factual context to meet the Article 30 knowledge standard. For intent, including the specific intent to discriminate on the grounds of gender, the accused was aware of his own actions in targeting males as perceived rebels and the relevant factual context of patriarchal society at the time. Being male, in addition to being four of fighting age and not from specific locations, was pivotal to the perpetrator's definition of their target group, as well as their perception of individual victims as rebels and targeting them on that basis. The accused was entirely aware and intentional in his targeting of men and boys in a discriminatory manner, deprivation of their fundamental rights, and commission of related crimes, all the elements of gender persecution. Your Honors, this concludes my submissions, and I will now pass the floor to Ms. Whitford, who will present in the remaining time on Delege.
Thank you very much, Ms. Morris. Yes, Ms. Whitford.
Good afternoon, Madam President, Your Honours. In the remaining time that we have, I will be addressing Your Honours in relation to, first, the consistency and reliability of the evidence establishing the Delege criminal incident. Secondly, Abd-Al-Rahman's responsibility for the Delege incident. Third, a brief section on the scope of the charges, in particular the question of additional victims, and lastly, if time, on the Facebook material. Beginning with the Delege evidence. During the course of this trial, Your Honours heard evidence from some 19 witnesses to this incident. The core of that evidence consists of first-hand accounts of witnesses who made direct observations of each phase of this incident. Witnesses saw Abd-Al-Rahman and his co-perpetrators ready themselves and set off from the Garcilla army base. Witnesses saw the Janjaweed and government forces surround Delege and go through the streets and from house to house, arresting Fur males who had been displaced by attacks in the region. Witnesses saw Abd-Al-Rahman at the Delege police station, where some 200 Fur males were brought and made to lie face down on the ground for hours in the burning sun, without food and water, while being beaten and abused. Witnesses saw Abd-Al-Rahman walking on the detainees' backs. They saw him take his axe and hack into the heads of two of those defenseless men, killing them. Witnesses saw and heard Abd-Al-Rahman give the order that detainees be loaded onto land cruisers to be driven to sites outside Delege, where some 130 of them were shot and killed. These witnesses were members of government forces, as well as ordinary civilians, farmers, traders, students. Several witnesses recounted their own arrest and abuse in Delege. Many told of family members and friends killed in the executions. Some witnesses were children at the time of these events. The impact of those traumatic experiences, which for many lasts until today, some 20 years since the events, was many times plain to see in this courtroom. And the evidence of those witnesses weaves a cohesive narrative, far from each telling a different story of what happened in Delege, as the defense would have you believe. There is a remarkable degree of consistency and corroboration across their accounts. First, regarding Abd-Al-Rahman's presence during the incident. 14 prosecution witnesses saw the accused either in Delege or deploying to Delege from Garcilla on the first day of the incident. 10 of those witnesses, the ones marked in orange, had prior knowledge of the accused. They had seen or met him before the Delege events, and they knew who he was. Among those, P883 and P905 had a particularly strong basis of knowledge, and we set this out at paragraphs 20 to 27 of our brief. At paragraph 560 of the defence brief, the defence attempts to undermine P905's evidence by submitting that, quote, P905 was not even sure about seeing Ali Kushayb in Delege. But in the same passage of testimony cited by the defence, P905 was definitive that the accused was there. And when it was put to him in that passage, quote, even if you were in Delege, you did not see Ali Kushayb, did you? He answered, quote, I was with him. And I refer in particular to transcript 88 at page 82. Regarding the evidence that Abd-Al-Rahman killed 2 female detainees at the Delege police station with his axe. Regarding the first victim, known as Janif, we rely primarily on the first-hand accounts of 3 witnesses, P994, P907, and P905. These 3 witnesses, unconnected to each other, saw this event from 3 different perspectives. And as your honours will note, in paragraphs 549 to 554 of our brief, and contrary to the defence's submissions, their accounts do not contradict each other, they fit together. And the same is true of the evidence of 2 direct witnesses we rely on to establish the killing of the second victim, known as Sheikh Motor, P907 and P584. And we set out their evidence at paragraphs 558 to 559 of our brief. Both witnesses, again, unconnected to each other, stated that Abd-Al-Rahman went to Sheikh Motor, had a short conversation with him, hit him with an axe or stick. This caused him to fall to the ground, and Abd-Al-Rahman then ordered his men to throw his body or load it in a humiliating way onto the back of a Land Cruiser, which they did. Again, their accounts fit together. Regarding the evidence on the transports of detainees to execution sites, our case is and has always been that there were several transports to multiple sites. That is what was confirmed by the pretrial chamber and what the evidence proves. There is no lack of clarity on that point, as the defence claims at paragraph 607 of their brief. There is also no merit in the defence's assertion, in the same paragraph, that witness accounts, quote, differ dramatically in relation to how many detainees were transported and how many trips the vehicles made. And I refer your honours also to Annex 6 to the defence brief. In our brief at paragraphs 563 to 565, we set out the relevant evidence on those points. And your honours will note that there is in fact a lot of consistency across those witness accounts, even without taking into account the different vantage points of the witnesses, the fact that some witnesses did not see the whole loading process, the passage of time, the traumatic nature of these events, and so forth. The evidence is more than sufficient to establish the material facts that the vehicles were loaded, driven out of Delege, that they returned empty, and the process repeated several times. Regarding the evidence of execution sites outside of Delege, the evidence establishes that executions took place to the northwest of Delege in the area of Soja and to the south of Delege in the area of Koska. And we explain this in our briefs from 565 to 599. Contrary to the defence's submission, the evidence of what occurred at those sites is direct, consistent, and corroborated. For the site northwest of Delege, where Abd-Al-Rahman was present and ordered the execution, we rely on direct witness observations, information received by witnesses from reliable sources, evidence of a mass grave and bodies found subsequent to the executions, and evidence of efforts by Abd-Al-Rahman to conceal traces of the bodies at that site. And I refer Your Honours to paragraphs 564 to 579 of our brief. For the sites to the south of Delege, the evidence on those sites is again remarkably consistent. Your Honours are familiar with the satellite imagery now on the screen showing the area south of Delege. It was shown to witnesses during the trial. And we see locations of Delege and Koska on that imagery, and we have also marked various landmarks, Claire, that were identified by witnesses. We see Wadi Bukla, Tolda and Koska Mountain, and the road running between Delege and Koska. And as I will demonstrate in a moment, witnesses consistently identified this approximate area, circled in yellow, as a location where executions took place. On the screen now we see 4 images. On the left, 2 sketches drawn by witnesses, and on the right, 2 satellite images marked by witnesses. On all 4, we see again the town of Delege, the top of the image, and the village of Koska to the bottom left. In each we also see Wadi Bukla, now marked in blue, and also the road running from Delege to Koska, now marked in brown. And at the bottom of each image we can see a mountain range. In all 4 images, the witnesses marked this area, now circled in yellow, described as a khor between Koska and Tolda Mountains, as the place where executions occurred and where large numbers of bodies were found in the subsequent days. And these are but a few examples of the high degree of consistency, corroboration and reliability of the evidence establishing the Delege incident. Turning now, Your Honours, to Abd-Al-Rahman's responsibility for the Delege crimes. As Your Honours are aware, Abd-Al-Rahman is charged under several modes of liability for this incident: as a co-perpetrator, direct perpetrator, for ordering and for inducing the crimes. In the time that I have, I will deal with Abd-Al-Rahman's position of authority and influence, since this is relevant to several of the charged modes. I will then focus on how the scope of the Delege Common Plan is supported by the evidence, and this relates to Your Honour's question 23. Mr. Jeremy has already addressed Your Honours in relation to Abd-Al-Rahman's general position of authority and control, and what I would like to do is to highlight some of the evidence specific to Delege and respond to some of the defence arguments. There is ample evidence of Abd-Al-Rahman's position and of authority and influence in Delege. As with Mukhtar, the defence would have Your Honours focus on de jure positions and formal hierarchies, rather than look at the evidence of what actually happened on the ground. The evidence shows that when Abd-Al-Rahman gave orders to the Janjaweed and to government forces in Delege, his orders were complied with. And we give many examples of this in our brief at paragraph 659. And they are important orders, ranging from ordering that persons be arrested or released, ordering that land cruisers be loaded, and ordering that detainees be shot and killed at an execution site. And there are plenty of other examples. At the Garcilla Army Base, prior to deploying to Delege, Abd-Al-Rahman demanded that 3 detainees, who were being detained there by military intelligence, be handed over to him. When he was told that they should call the commander, he said, quote, "No, I am the commander. I was with him and I do not have time to wait for the commander." And I refer Your Honours to paragraph 528 of our brief. Abd-Al-Rahman then took custody of those detainees and transported them in his convoy to Delege. a military intelligence officer who was related to one of the detainees was assigned to Abd-Al-Rahman's convoy to keep an eye on him. However, as soon as the convoy arrived in Dallej, Abd-Al-Rahman made the military intelligence officer leave his convoy. And all 3 detainees were subsequently killed in Dallej during the incident. I refer Your Honours to paragraphs 528 and 568 of our brief for that evidence. At the police station, Abd-Al-Rahman ordered a police first sergeant to bring a detainee out of the cell. And after Abd-Al-Rahman killed the detainee, he instructed the first sergeant to throw the body outside. And I refer Your Honour to paragraphs 553 of our brief. And this last example is consistent with other evidence in the case demonstrating that the police were powerless to stop this operation. The police were far outnumbered by the Janjaweed, and some police were Fur and were themselves afraid of being targeted. They had no radio or communication device, and even if they did, who would they call for help? And I refer Your Honours to paragraph 534 of our brief for the evidence on those points. The defence asserts at paragraphs 658 and 662 of their brief that the detainees were, quote, always under the direct control of Sergeant Juma Hassan Fadli, a police officer who worked at the Dallej police station. There is no support for that proposition. The 2 witnesses cited by the defence, P643 and 935, simply stated that Fadli was head of the police station at the time. In another attempt to shift the blame onto anyone but Abd-Al-Rahman, the defence asserts that military intelligence officer Hamdi was in charge of the entire operation in Dallej, citing to witness P883. This argument is made at paragraphs 332, 583 and 645 of the brief. P883 stated that Hamdi oversaw the search. P883 never stated that Hamdi commanded, quote, all operations in Dallej. In fact, when asked whether the Dallej operation was, quote, under the direct command and supervision of the SAF, P883 stated no. And I refer Your Honours to transcript 74 at page 65 and paragraph 627 of our brief. At paragraph 606 of the defence brief, relying on a selective reading of the evidence of 643, the defence asks Your Honours to infer that if anyone ordered the loading of the detainees onto vehicles or that they be taken to execution sites, it must have been Hamdi. To begin with, there is no proper evidentiary basis from which Your Honours could draw that inference. But to draw that inference, Your Honours would also have to discount the evidence of 4 direct witnesses who stated that Abd-Al-Rahman gave the order for the vehicles to be loaded, the evidence of one of those witnesses, P994, who watched the loading, who knew Hamdi, and who stated that he only saw Hamdi near the Dallej army base that day and not at the police station. And I refer Your Honours to paragraph 66 of his statement. And the evidence of P883, who stated that after the searches and arrests, Hamdi left Dallej to go to Kailek, and the events then unfolded. And that's in our brief at paragraph 627. As in Mukhtar, the defence's efforts to shift the blame onto others, such as Hamdi, fail. The role of Hamdi or any other co-perpetrator in the events does not absolve Abd-Al-Rahman of criminal responsibility. They are co-perpetrators. They were working together. Abd-Al-Rahman made an essential contribution to the common plan. He is therefore liable for all crimes that occurred within the framework of that common plan, where Your Honours are satisfied that he intended those types of crimes to be committed or knew that those types of crimes would be committed in the ordinary course of events. And that brings me, Your Honour, to the Dallej Common Plan, and this relates to Your Honour's question number 23. We see the wording of the plan now on the screen. In simple terms, the evidence shows that the plan involved searching for and arresting Fur males displaced from the conflict areas, abusing and humiliating them, and then killing them. In this case, the existence and scope of the plan is inferred from circumstantial evidence. The wider circumstances in which the crimes occurred and the events on the ground, in particular the concerted actions of the co-perpetrators, demonstrate what the plan was. And what I'd like to do now is highlight some of the main features of the evidence that we rely on to establish the common plan. First, I'll talk about the overall context of the Delege incident. Then I'll talk about the events on the ground before, during, and after the incident, and in particular, Abd-Al-Rahman's own acts and conduct. Turning first to the overall context. The Delege events occurred in the midst of a large-scale counter-insurgency campaign in Wadi Sala and Mukjar, in which Abd-Al-Rahman played a major role. Having been chosen to lead the Janjaweed in those localities, Abd-Al-Rahman got the government's backing to fight its counter-insurgency. The government gave him money and weapons, and he formed relationships with senior leaders like Ahmed Haroun. P883 explained how the government's backing boosted the authority of Abd-Al-Rahman. When asked whether the Ghassila police ever conducted investigations into the actions of Abd-Al-Rahman or his Janjaweed, P883 responded, quote, "No, they did not carry out any investigations because, in essence, they had neither the capability nor the authority to hold Ali Kushaib accountable." And when asked to explain why, P883 answered, quote, "Ali Kushaib back then had prerogatives vested in him by a minister attached to the Ministry of the Interior, i.e. Ahmed Haroun. Probably those powers were granted even by a higher authority." And I refer to transcript 72, pages 18 to 19. Starting in August 2003, Abd-Al-Rahman led the Janjaweed in a series of joint operations with government forces in Kudum and Bindizi, Deresa, Silik, Tanako, Sindhu, and Mukjar before the Delege incident in March 2004. The events in Mukjar are especially significant for Delege. The crimes in both locations were committed only about a week apart by many of the same perpetrators against the same targeted group and with a strikingly similar modus operandi. Like in Mukjar, Delege was at the time filled with displaced people who had fled joint attacks by Janjaweed and government forces in the region. Among them were displaced people from the region of Arawala, which Abd-Al-Rahman had attacked as part of the Sindhu operation a short time before. Abd-Al-Rahman and many of the same co-perpetrators as in Mukjar, including Hamdi, Hasaballah, Abdul-Manim, and Idris, targeted for males from among the displaced in Delege who they perceived as belonging to or being associated with or supporting the rebel armed groups. This discriminatory targeting, using proxies or shortcuts, is how they decided who to arrest, humiliate, torture, and kill in both places. And pursuant to essentially the same common plan, within about a week, Abd-Al-Rahman and his co-perpetrators murdered at least 177 Fur men and boys in Mukjar and at least 137 in Delege. As such, the Mukjar incident was, in many ways, a blueprint for the crimes in Delege. Turning now to the initial stages of the Delege incident, the evidence shows that the co-perpetrators planned and prepared for the Delege operation. On the first day of the incident, co-perpetrator Idris relayed instructions from Commander Bakhat to members of the SAF as they stood in lines in the courtyard of the Ghassila army base. Idris instructed the troops to ready themselves to deploy for an operation in Delege. And that's at 526 to 527 of our brief. That same day, Abd-Al-Rahman came to the Garcilla base, and as I mentioned earlier, he demanded custody of 3 detainees being held by military intelligence. Abd-Al-Rahman had ordered the arrest of 2 of those men, Sheikh Ismail Abdulaziz and Hassan Adam Musa, and he had been chasing the 3rd man, Omda Muhammad Suleiman of Tanako, ever since he had fled Abd-Al-Rahman's Tanako operation some time before. Using the same pretext as in Mukjar, Abd-Al-Rahman said he was taking the detainees to Zalanji, but in fact, all 3 were subsequently killed during the Delege incident. After taking custody of those detainees, Abd-Al-Rahman deployed to Delege in a convoy of around 13 land cruisers, including SAF and military intelligence. Co-perpetrators Hamdi, Hassaballah, Abdul-Munim, Mansour, and Idris also deployed from the Garcilla base to Delege. Regarding the nature of this mission, just like in Kudum and Bindisi incident and Mukjar, the evidence shows that there was no rebel armed group based in Delege nor any rebel attack to be repelled. This was not a combat operation. It was about rounding up and hunting down displaced fur males, just like they had done in Mukjar about 1 week before. Turning now to the evidence of what occurred on the ground during the incident, starting with the search. P883 stated that military intelligence officer Hamdi gave instructions for the search and was assisted by military intelligence officers Abdul-Munim and Mansour. Those 2 officers had been deployed in Arawala and so could identify people who had fled from that area. And all 3 are named as co-perpetrators in the common plan. Although military intelligence gave instructions, the evidence shows that Abd-Al-Rahman's Janjaweed forces were the largest force on the ground that day. The fact that over several hours, Janjaweed and government forces surrounded Delege and then systematically searched the town, going through the streets and from house to house, arresting fur males and bringing them to the police station in huge numbers, demonstrates that this was a coordinated effort. And Abd-Al-Rahman himself participated in the search. Abd-Al-Rahman was present and gave orders for the arrest of Omda Adam Kandiri, the community leader of Forgo, one of the major villages near Arawala. When family members protested, Abd-Al-Rahman told them, quote, "If you step out and follow the vehicles, you will be shot." And later, Abd-Al-Rahman was heard to tell Omda Kandiri, quote, "This is your last day on earth. Get ready for the doomsday." And Omda Kandiri was subsequently killed during the Delege incident. Your Honour, I note the time. It's now 4 o'clock.
You can complete.
Carry on.
Yeah, you by our rating, you've got another 10 minutes or so.
Yes.
Well, until 6 minutes, but no, you can certainly go on until...
Yes, I can finish the Delege section in about 5 minutes.
Right.
And then my submissions regarding the scope of the charges are only 5 minutes, Your Honour. In relation to the Facebook submissions, this was in response to one of Your Honour's questions. I'm prepared to address it, but we can also...
No, we'll put it. What we'll do is we'll put over the Facebook question until Friday, until everybody's speech is completed.
Very well, thank you, Your Honour. Turning now to the events at the police station. Ample witness evidence puts Abd-Al-Rahman at the police station, where likely more than 200 fur males were detained face down on the ground. Abd-Al-Rahman's acts and conduct at that location again show that what was unfolding there was according to plan. As the detainees lay helpless on the ground, surrounded by Janjaweed, Abd-Al-Rahman walked on their backs. He patrolled around them and told them, quote, "You escaped from Arawala, and then you came here. "Even if you fly to the sky, I will get you." That's in transcript 86 at page 45. In front of local villagers, detainees, police and Janjaweed, Abd-Al-Rahman used his axe to chop into the heads of 2 of the men detained there, killing them both. Abd-Al-Rahman had brought one of those arrested men, Janif, the former PDF coordinator in Garcilla, to the police station himself. And Abd-Al-Rahman accused Janif of giving weapons and ammunition to, quote, the Tora Bora in Arawalla. Before killing him with his axe, Abd-Al-Rahman told Janif, quote, "I'm not going to even spend one single shot on you because shots are expensive. We pay money for it. So all what I'm going to use is this axe." The second man was community leader Sheikh Motor from Massa village, not far from Arawalla. And before killing him with his axe, Abd-Al-Rahman humiliated Sheikh Motor in front of the other detainees, telling him, quote, "You are a very fat person. You must have eaten people's money." And of course, as we know, Abd-Al-Rahman did not stop there. He ordered the Land Cruisers be loaded, and at one execution site he ordered the detainees be shot and killed. Abd-Al-Rahman's own acts and conduct on the ground during the Delege incident are some of the clearest evidence that he was part of the common plan and what it entailed. Turning now to the evidence of what occurred after the Delege incident. The evidence shows that Abd-Al-Rahman received and complied with orders from the SAF to move bodies left behind at the execution site northwest of Delege in order to conceal evidence of the executions. And we reference that in our brief at 578 to 579. And we say this evidence corroborates that Abd-Al-Rahman was a member of the common plan. And in support for that position, I refer your honours to the trial judgment in the Popovic et al. Case from the ICTY, in which the trial chamber found that Nikolich's participation in the JCE to murder was corroborated by his participation in the reburial operation. And I refer your honours specifically to paragraph 1391 of the trial judgment. And at this point, I can provide a very brief answer to question 18, your honours. I can indicate that of the types of evidence that are listed in that question, this reburial evidence that I've just mentioned is the only evidence we rely on with respect to Abd-Al-Rahman's criminal responsibility. And I note that we also rely on this evidence in relation to the jurisdiction point as an indicator that at the time the killing in Delege was criminal and that the government of Sudan and Abd-Al-Rahman knew it was criminal, and that's why they tried to cover it up. And we reference that at paragraph 679 of our brief. To conclude on the Delege Common Plan, I've tried in this short time to highlight some major features of the evidence we rely on. In summary, the overall context, including the pattern of crimes involving the same perpetrators against the same targeted group, especially with regard to Mukjar, the evidence of planning and preparation, the evidence of coordination between the co-perpetrators during the incident, and Abd-Al-Rahman's own acts and conduct before, during, and after the incident, including the evidence of his specific and deliberate targeting of community leaders. We also point to Abd-Al-Rahman's pre-existing relationships with co-perpetrators, and lastly to his position of authority and influence. He was no simple foot soldier, your honours. He was the leader of the Janjaweed, the largest force on the ground in Delege that day. And this fact, in combination with all of the other evidence in the case, further demonstrates that Abd-Al-Rahman was a member of this common plan. And in the next few minutes, I'd like to very quickly address the scope of the charges, and in particular, the second part of question 14 relating to the number of charged victims. The defence submits that your honours should only enter convictions for the crime of murder with respect to the number of victims included in the confirmed charges. And this argument is found in the defence brief at paragraphs 415, 537 and 644, and it's made in relation to all 3 of the criminal incidents. This issue is, of course, relevant to the question of the scope of Your Honour's Article 74 judgment, and therefore Article 74, subsection 2 is relevant, and in particular, quote, that the decision shall not exceed the facts and circumstances described in the charges and any amendments to the charges. The position taken by the defence on this issue is contrary to the decision of the pre-trial chamber in this case on the prosecution's request to amend the charges, and I refer Your Honours to decision 626. In its final brief, the defence asserts that the pre-trial chamber erred in law in rendering that decision, and it makes that argument at paragraphs 537 and 644. The pre-trial chamber found that an amendment to the charges to include additional victims was not necessary in this case. The pre-trial chamber also made clear that its findings in the confirmation decision on specific numbers of alleged victims was not intended to limit or restrict the trial chamber. And I refer Your Honours to paragraphs 18, 20 and 22 of that decision. And very quickly, because I think the text is important, if we can look at paragraph 18, noting the limited purpose and scope of confirmation proceedings, the pre-trial chamber held, quote, accordingly, such indication ought not to be understood as limitative or restrictive. It is not a finding that there can be no further victims beyond those specifically mentioned. Rather, as revealed by relevant portions of the confirmation decision, the chamber recognised that the extent of the victimisation in connection with the confirmed charges of murder and rape was broader than the individual instances it specifically mentioned. The pre-trial chamber goes on at paragraph 23. I won't read it out, but essentially the pre-trial chamber is saying that so long as other persons who fall within the same temporal and geographical parameters, as well as within the charged role of the accused, a trial chamber assessing the evidence may include those persons in the crimes as charged. And I note that this approach is consistent with jurisprudence from the appeals chamber on specificity of charging, in particular the Entaganda appeals judgment, paragraphs 326, 327, and that was followed in the Al-Hassan judgment on the Regulation 55-2 decision. In the present case, the additional victims alleged for each of the criminal incidents clearly fall within the facts and circumstances of the confirmed charges. The material facts are the same, the temporal and geographical parameters are the same, and the role of the accused is the same. As a result, we submit that Your Honours can and should enter convictions for murder with respect to all victims established by the evidence and not only those confirmed by the pre-trial chamber. And that concludes my submissions, Your Honour, and thank you for allowing the extra time.
Yes, thank you very much, Ms. Whitford. So that concludes the final address by the prosecution. Is that right?
Yes, it does, Your Honors, and if I can just briefly thank you for your attention today and throughout this trial and bearing with us. Thanks to the defense and the LRB teams as well for the collegiality. We're confident we've met our burden, and we're confident there'll be a just verdict. Thank you.
Thank you very much, Mr. Nielsen. So we'll sit again tomorrow morning at 9:30, and we'll hear then from the representatives of the victims. And I think you've got effectively a session. Is that right, Ms. von Stinghausen?
I've got generous 1.5 hours.
Yeah, it's a session. Yes, thank you very much. In that case, we'll adjourn until 9:30 tomorrow morning.
All rise. We will away.